The presumption of innocence is a basic human right under the Universal Declaration of Human Rights. The Republic of India too, like any other liberal democracy, claims to guarantee this right to all its citizens. It is true to an extent that even most dreaded terrorists and criminals involved in the most heinous of crimes are entitled to this right. But unfortunately, if you belong to a non-scheduled caste or tribe, then you are not fully entitled to enjoy this basic human right. One such unfortunate person is Vishnu Tiwari. In the year 2000, a woman belonging to a scheduled caste accused Vishnu Tiwari of rape. The Sessions Court found him guilty and sentenced him to a 10-year imprisonment. The court slapped an additional sentence of life imprisonment under the Scheduled Castes and Tribes Prevention of Atrocities Act 1989, commonly known as the SC/ST Act. After 20 years, the Allahabad High Court found the charges against him to be false and acquitted him. It turned out that Vishnu had a property dispute with the accuser's family, and the latter conspired to levy false charges of rape and caste-based atrocity against him. Since under this act, there is no provision of anticipatory bail for the accused, and arrest can be made arbitrarily without any preliminary inquiry. The accusers were confident of their conspiracy. Thanks to our legal system, they succeeded in keeping an innocent man behind the bars for 20 long years. A similar case is that of Rajesh Misra, an RTI activist and whistleblower who raised his voice against a corrupt village head and his associates. To seek revenge, the village head, who belonged to a scheduled caste, accused Rajesh of caste-based abuse and attempt to murder. Rajesh was sent to prison. It later turned out that the village head had immolated himself, and Rajesh was not even present at the spot of the incident. However, this was not enough for Rajesh Misra to secure bail. Even his request to attend his mother's funeral was denied by the court. The case is still active in the court. In yet another case, a petitioner threatened the judge of slapping the SC/ST Act on him if the verdict was not delivered favorably. I shared these three cases just to show how unfair and draconian the SC/ST Act is. There are innumerable such cases where this act has been used to destroy the lives of innocent people and their families. The act claims to prohibit discrimination, prevent atrocities and hate crimes against scheduled castes and scheduled tribes. The act gives several powers to individuals belonging to SC/ST communities, such as preventive detention of potential offenders, denial of anticipatory bail, granting arms license to SC/STs, empowering government to impose collective fines, and so on. Often, the act is used by people belonging to the SC/ST category to settle personal scores. Many a times, the act is also used for political and ideological purposes. This is evident from the fact that in 2015, out of 15,638 cases registered under the Act, 11,024 cases resulted in acquittal or discharge, and 495 cases were withdrawn by the accusers. Only 4,119 cases resulted in conviction. This means almost 75% of cases resulted in acquittal or withdrawal of the cases. The data clearly shows how the act is used for false accusations. So, the question is, if a court can grant anticipatory bail even in the most heinous offences including murder, rape, dacoity, robbery, NDPS, sedition, etc., which are punishable with longer periods depending upon parameters for grant of anticipatory bail, what makes the legislature think that anticipatory bail should be denied under this particular act? Even a more pertinent question is, how come such a draconian act was enacted in the first place? Well, the answer is not that complicated. The act is a result of systematic propaganda about caste-based atrocities, first by the British colonizers and their sepoys, and then by the leftist intelligentsia and politicians who thrive on caste-based politics. While the colonizers used it to justify their rule, Aryan invaders have no right to oppose us and to convert Hindus to Christianity. The left is using it to realize a communist revolution in India. Politicians and small-time social justice activists happily live off the propaganda. The whole ecosystem is designed to exploit fault lines within the Hindu society and to pitch one caste against the other in a perpetual struggle. A careful scrutiny of the stories of crimes against SCs and STs reported by the media reveals a propensity for sensationalization and a commitment to a certain narrative. Consider this news report of the Hindu, which draws the reader's attention to the rising crimes against SCs and STs. The report quotes data from the National Crime Records Bureau (NCRB) that shows a rise of 7% and 26% of crimes against SCs and STs respectively in 2019. That much is true, but it is only a half truth, because if we dig the NCRB data deeper, we find that a total of 45,935 cases were registered for committing crimes against SCs and 8,257 against STs, adding up to a total of 54,192 cases. That is roughly 1.05% of the total 51,56,172 crimes registered in 2019, while the combined proportion of SC/ST population is 25.24% in the total population of India. So we can say that 74.76% of non-SC/STs face 98.95% of crimes, while 25.24% of SCs and STs faced 1.05% of crimes. Therefore, the fair conclusion is that the non-SC/ST population faces 32 times more crime than SC and ST. This analysis does not even discount the crimes committed against SC/STs by the members of SC/ST communities themselves. But it is sufficient to demonstrate that the rhetoric of caste atrocities and oppression does not stand the test of basic critical scrutiny. The prevalent narrative of caste-based atrocities has another major lacuna, declaring certain communities as SC/ST is arbitrary, and this superficial exercise was originally carried out by the British. For example, if the social dynamics between Brahmins and Charmkars is taken as representative of caste-based discrimination, what explains the exact same social dynamics between Charmkars and Valmikis, both SC communities? If Brahmins are painted as evil oppressors in the former scenario, why are both parties given a clean sheet in the latter? The fact of the matter is that the complex web of Indian society has been reduced to manageable political hierarchies by politicians and ideologues. In this scheme, blaming all ills on the so-called upper caste, most notably Brahmins, is a convenient shortcut towards achieving ideological goals and electoral success. In 2018, the Supreme Court struck down some unjust provisions of the SC/ST Act, noting, "We have already noted the working of the Act in the last 3 decades. It has been judicially acknowledged that there are instances of abuse of the Act by vested interests against political opponents in panchayat, municipal or other elections to settle private civil disputes arising out of property, monetary disputes, employment disputes and seniority disputes." It may be noticed that by way of rampant misuse, complaints are largely being filed particularly against public servants, quasi-judicial, judicial officers with oblique motive for satisfaction of vested interests. But many SC/ST groups, supported by almost all political parties and the left intelligentsia, came out on the streets demanding the reinstatement of the same draconian provisions, forcing the government to surrender to their atrocious demands. Indian society has reached a point where the anti-Brahminism rhetoric of British era has transformed into a normalization of hatred for Brahmins and other upper castes. It is not hard to predict where this insidious narrative, empowered by a draconian law, is leading to. If we want a harmonious and peaceful future for Hindu society, caste-based hatred must be called out, and institutionalized discrimination against upper caste communities must end now. This is Shubham Sharma for Upward.